I found the foreclosure notice taped to my front door on a Tuesday morning in April, and my first thought was that someone had made a terrible mistake because I had never missed a single payment on my property in Sedona, Arizona. The paper fluttered in the desert wind as I ripped it down, my coffee mug still warm in my other hand, and read the words that would turn my entire life upside down. According to the document, my 2-acre parcel of land adjacent to my main residence had been sold at auction 3 weeks ago to settle an outstanding HOA debt of $47,000. My name is Gabriel Yates, and I'm a 42-year-old software consultant who moved to Sedona 5 years ago, specifically because I wanted peace, quiet, and distance from the corporate chaos of San Francisco. I purchased my main home and the adjacent vacant land with the intention of eventually building a workshop and greenhouse. The land was beautiful, untouched desert with views of the red rocks that made this area famous. I paid my HOA dues on time every single quarter without fail. So when I saw this notice claiming I owed nearly $50,000, I knew something was catastrophically wrong. I immediately called the phone number listed on the notice. A woman answered on the third ring with a chipper voice that seemed completely inappropriate given the circumstances. Desert Winds Homeowners Association. This is Brenda speaking. How may I help you? This is Gabriel Yates on Juniper Canyon Road. I just found a foreclosure notice on my door claiming you sold my land. This has to be a mistake. There was a pause, then the sound of typing. Let me pull up your account, Mr. Yates. Juniper Canyon Road, you said? Yes, number 847. More typing. Then her voice changed, becoming more formal. Mr. Yates, I am showing here that you have been delinquent on special assessment fees for the past 18 months. Multiple notices were sent to your address. When payment was not received, the association exercised its legal right to place a lien on your secondary parcel and proceed with foreclosure proceedings. What special assessment? I never received any notices about any special assessment. I pay my regular dues every quarter through automatic bank transfer. The special assessment was voted on at the annual meeting 2 years ago. All homeowners were notified by certified mail. The assessment was for infrastructure improvements, including new fencing around the community perimeter and upgraded security lighting. I felt my jaw clench. I never received any certified mail about this, and I definitely did not sign anything agreeing to this assessment. Who bought the land? I am not at liberty to discuss the details of the sale, Mr. Yates. If you have concerns about the process, you will need to speak with our president, Patricia Hendricks, or consult with an attorney. Put Patricia on the phone right now. Mrs. Hendricks is not in the office today. I can have her return your call. You can do better than that. Give me her cell phone number. I cannot give out personal contact information, Mr. Yates. I will leave her a message that you called. I hung up and immediately started searching through my records. I kept meticulous files of all my property-related documents, both digital and physical. I went through every piece of mail I had received from the HOA for the past 3 years. Regular quarterly dues notices, a few benign newsletters about community events, one notice about pool maintenance, nothing about any special assessment, nothing about $47,000, nothing about foreclosure proceedings. My hands were shaking as I grabbed my keys and drove directly to the HOA office, which was located in a small stucco building near the community entrance. The office was sparse, just a reception desk and a few filing cabinets. Brenda, a woman in her 50s wearing too much turquoise jewelry, looked up as I walked in. Mr. Yates, I was just about to call Mrs. Hendricks for you. Where are the certified mail receipts proving you sent me notices about this assessment? She shifted uncomfortably. Those would be in the file. Mrs. Hendricks handles all of that. Get the file. I really think you should wait to speak with Mrs. Hendricks. Get the file, or I am calling my attorney right now and we are going to start discussing wrongful foreclosure lawsuits. Brenda disappeared into a back room. I could hear filing cabinets opening and closing. She returned 5 minutes later with a manila folder that looked suspiciously thin. She placed it on the counter between us but kept her hand on it. I can show you some of the documents, but some of this information is confidential association business. My land just got sold out from under me. Show me everything. She reluctantly opened the folder. Inside were several documents, including what appeared to be the original special assessment notice, dated nearly 2 years ago. There was a list of properties in the community and corresponding assessment amounts. My secondary parcel was listed with an assessment of $47,000, which was significantly higher than most other properties on the list. Why is my assessment so much higher than everyone else's? The assessment was calculated based on square footage of owned property. Your vacant land is 2 acres, which is larger than most residential lots. That is not how square footage works for assessments. You assess based on improved property value, not raw acreage. Show me the certified mail receipts. She flipped through the papers. There were several green certified mail cards clipped to various notices. She showed me one dated 18 months ago. The card had my address on it. The signature line showed what was supposed to be my signature accepting delivery. Except it was not my signature. I stared at the card. The handwriting was crude, blocky letters that looked nothing like my actual signature. My real signature has a very distinctive flow, with the G and Y connected in a specific way that I have been writing the same way since high school. This signature looked like someone had tried to copy my name without ever seeing me actually write it. This is not my signature. Brenda's eyes widened slightly. The Postal Service confirmed delivery. This is forged. I never signed for this. I never received this notice. Mr. Yates, that is a serious accusation. And selling someone's land based on forged documents is a serious crime. I want to speak to Patricia Hendricks immediately. Call her right now, or I'm walking out of here and going straight to a lawyer. Brenda picked up the phone and dialed. I could hear it ringing on speaker. A woman's voice answered, clipped and annoyed. What is it, Brenda? I'm at the salon. Mrs. Hendricks, Gabriel Yates is here in the office. He's very upset about the foreclosure on his vacant parcel. We followed proper procedure. Everything was done by the book. If he has concerns, tell him to hire an attorney. He is claiming the certified mail signature is forged. There was a long pause. Put him on. Brenda handed me the phone. Mrs. Hendricks, I am looking at a certified mail receipt with a signature that is absolutely not mine. I never received notice of any special assessment. I never had any opportunity to contest these charges. You sold my property illegally. Patricia's voice was cold and measured. Mr. Yates, the association has full legal authority to levy assessments and enforce collection through liens and foreclosure when necessary. You were given multiple opportunities to pay the assessment or set up a payment plan. You ignored all correspondence. I did not ignore anything because I never received anything. Someone forged my signature on this receipt. That is a very serious accusation that I am sure you cannot prove. The Postal Service delivered the notice, and someone at your address signed for it. If you are having issues with people in your household signing for your mail, that is not the association's problem. I live alone. Nobody else signs for my mail. This signature is forged, and I'm going to prove it. Who bought my land? Another pause. The land was purchased by Desert Winds Development LLC at a properly noticed public auction. Who owns Desert Winds Development? That is not relevant to this conversation. If you want to contest the foreclosure, you need to file an action in court. I suggest you do so quickly because the statute of limitations for challenging a foreclosure sale in Arizona is quite short. Now, if you will excuse me, I have an appointment. She hung up. I took out my phone and photographed every document in that folder before Brenda could close it. She protested, but I ignored her. I photographed the assessment notice, the certified mail cards, the foreclosure filing, and the auction notice. Then I walked out and drove straight to the office of Thomas Rodriguez, a real estate attorney whose billboard I had seen on Highway 89A. Thomas's office was in a modern building with views of the Red Rocks. He was a man in his mid-50s with graying hair and the kind of calm demeanor that probably served him well in court. I explained the entire situation while he took notes on a yellow legal pad. "Do you have the documents?" he asked. I showed him the photos on my phone. He studied them carefully, zooming in on the certified mail signature. "This does not look like your signature." "Nothing like it. Here, look." I pulled out my driver's license and credit card, both with my signature on them. I also signed my name on his legal pad several times. The difference was obvious. My actual signature was fluid and connected. The signature on the certified mail receipt was choppy and unnatural. Thomas nodded slowly. This is potentially a strong case, but we need to act fast. In Arizona, you generally have 6 months from the date of the foreclosure sale to challenge it, but there are some exceptions if fraud is involved. The first thing we need to do is file a motion to void the sale based on fraud and forgery. We will also need to get a handwriting expert to analyze these signatures. How long will that take? The expert analysis, probably 2 weeks if we can get someone good who is available. The court case, that depends on the judge's schedule, but we should be able to get an emergency hearing within 30 days given the circumstances. What are our chances? He leaned back in his chair. If we can definitively prove the signature was forged, and if we can show you never received proper notice, we have a solid case to void the sale. The problem is going to be proving that the HOA knew about the forgery or was negligent in verifying it. If they can argue they relied on the Postal Service confirmation in good faith, it gets more complicated. The whole thing stinks. The assessment amount was calculated wrong. I never got any notices, and now I find out the land was sold to some LLC. I want to know who owns that company. I will run a search on Desert Winds Development. That information should be public record with the Arizona Corporation Commission. Thomas pulled up his computer and typed for a few minutes. His eyebrows rose. Well, this is interesting. Desert Winds Development LLC was formed 4 months ago. The registered agent is law firm, but the managing member listed on the articles of organization is Patricia Hendricks. I felt my face flush with anger. The HOA president bought my land through her own company. It appears so. That's a massive conflict of interest and potentially fraudulent self-dealing. This changes everything. We are not just talking about a foreclosure dispute anymore. If Patricia used her position to orchestrate a fraudulent foreclosure in order to purchase your property for herself, that is criminal fraud. So what do? We file the motion to void the sale immediately. We hire the handwriting expert. And we also file a complaint with the Arizona Attorney General's office regarding the fraud. If the Attorney General decides to investigate, Patricia could be facing criminal charges. How much is this going to cost me? Thomas quoted me a retainer fee of $15,000. It was a lot of money, but the land was worth at least $200,000. I wrote the check. Over the next 2 weeks, Thomas worked quickly. He filed a motion to void the foreclosure sale in Yavapai County Superior Court, arguing fraud, forgery, and self-dealing by the HOA president. He also hired Dr. Margaret Chen, a forensic document examiner based in Phoenix who had testified in dozens of cases involving questioned signatures and handwriting analysis. Dr. Chen came to Thomas's office on a Wednesday morning to examine the original documents which we had subpoenaed from the HOA. She was a petite woman in her 60s who wore thick glasses and spoke with the precision of someone who had spent decades studying minute details. She examined the certified mail receipt under a magnifying glass and then with some kind of specialized digital microscope. She had me sign my name multiple times on different types of paper with different pens. She asked me questions about my signature's evolution, whether I had ever changed my handwriting style, whether I had any injuries that affected my writing. After about an hour, she looked up. "Mr. Yates, this signature on the certified mail receipt is definitely not yours. The letter formations are completely different. Your authentic signature shows a strong rightward slant, connected letters, and a very specific way of forming the capital G with a looped tail. The questioned signature is printed rather than cursive, shows hesitation marks indicating the writer was copying rather than writing naturally, and has none of the individual characteristics of your genuine signature. In my professional opinion, this is a forgery. Can you testify to that in court?" "Absolutely. I will prepare a detailed report with photographic comparisons and my analysis. This is actually one of the more clear-cut cases I have seen. Whoever forged this did not even attempt to match your writing style. Could you tell who did forge it?" "I would need samples of the suspected forger's handwriting to make a comparison. Do you have any documents written by the HOA president or staff?" Thomas interjected. "We can subpoena handwriting samples from Patricia Hendricks and her staff as part of the discovery process." Dr. Chen nodded. "That would be helpful. Sometimes forgers unconsciously incorporate aspects of their own handwriting into the forgery. If I can compare this signature to samples from the suspects, I might be able to identify the forger. The court hearing was scheduled for 3 weeks later. In the meantime, Thomas filed subpoenas for all HOA records related to the special assessment, foreclosure, and sale. He also subpoenaed Patricia Hendricks's personal financial records to trace the money flow. The documents that came back were revealing. Patricia had purchased the land through her LLC for only $75,000 at the auction, which was significantly below market value. There had been no other bidders at the auction, which was suspicious. The auction notice had been published in a small local newspaper on a single day, which technically met the legal requirement but virtually guaranteed no one would see it. Even more damning, Thomas discovered that the special assessment itself had never been properly voted on. The HOA bylaws required a vote of at least 60% of homeowners to approve any special assessment over $10,000 per property. The meeting minutes showed only 15 homeowners present out of 63 total properties. That was less than 25%, nowhere near the required threshold. The entire assessment was invalid from the start, Thomas explained when he showed me the documents. They did not have the votes to approve it. Everything that followed, the lien, the foreclosure, the sale, it was all based on an invalid assessment. How did they get away with this? Most people do not read their HOA bylaws carefully. They probably figured no one would challenge it. And Patricia had something to gain personally, so she pushed it through. What about the other homeowners who paid into this assessment? Were they all scammed too? Potentially. We might need to notify them that the assessment was invalid. But that is secondary to your case right now. The week before the hearing, we received the results of Thomas's investigation into Desert Winds Development LLC. It turned out Patricia had not acted alone. Her business partner in the LLC was her husband, Richard Hendricks, and the company's accountant was Mark Sullivan, who also happened to be the HOA treasurer. This was a conspiracy, Thomas said. Patricia used her position as HOA president to create a fraudulent assessment, forge your signature on delivery receipts to cover up the lack of notice, push through an invalid foreclosure, and then purchase your land through her own company at a below-market price. Her husband and the HOA treasurer were in on it. This is organized fraud. Should we go to the police? I already contacted the Yavapai County Sheriff's Office and the Arizona Attorney General's Fraud Division. They are both interested. But the criminal investigation will take time. Our immediate goal is to get your land back through the civil case. The night before the hearing, I could barely sleep. I kept thinking about Patricia Hendricks sitting in her office, orchestrating this entire scheme, thinking she could steal my property and get away with it. I thought about the forged signature, the fake meetings, the sham auction. It was audacious and brazen and incredibly stupid because she had left a paper trail. The hearing was held in the Yavapai County Superior Court in Prescott. The courtroom was formal and intimidating, with dark wood paneling and the seal of Arizona mounted behind the judge's bench. Judge Sandra Morrison presided, a woman in her early 60s with sharp eyes and no-nonsense demeanor. Patricia Hendricks arrived with her attorney, a slick-looking man in an expensive suit named David Werner. Patricia was exactly what I expected, a woman in her early 50s with perfectly styled blonde hair, too much makeup, and an expression of supreme entitlement. She looked at me like I was an insect that had crawled into her clean kitchen. Thomas presented our case first. He walked through the timeline of events, introduced the certified mail receipt with the forged signature, and explained the conflict of interest with Patricia buying the land through her own LLC. He also presented the evidence that the special assessment had never been properly voted on. Then Dr. Chen took the stand. She was an excellent witness, calm and professional. She explained her credentials, her methodology, and her findings. She had prepared large poster boards showing side-by-side comparisons of my genuine signature and the forged signature. The differences were stark and obvious even to a layperson. In my professional opinion, based on 30 years of experience as a forensic document examiner, the signature on the certified mail receipt is not genuine, Dr. Chen testified. It is a forgery, and not a particularly sophisticated one. The forger made no attempt to replicate Mr. Yates's actual writing characteristics. Could this signature have been created by Mr. Yates perhaps writing in a hurry or while injured? Thomas asked. No. The fundamental characteristics of a person's handwriting remain consistent even under stress or injury. This signature shows completely different letter formations and writing habits. It was written by a different person. Patricia's attorney cross-examined Dr. Chen, but she held firm on her conclusions. He tried to suggest that handwriting analysis was subjective and unreliable, but Dr. Chen calmly cited numerous court cases where handwriting evidence had been accepted and upheld. Then, Thomas called me to the stand. I testified about my property purchase, my payment history with the HOA, and my complete lack of knowledge about the special assessment. I explained how I kept detailed records and never received any notices. I described finding the foreclosure notice and my immediate attempts to resolve the situation. Patricia's attorney tried to paint me as irresponsible, suggesting I had ignored the notices and was now trying to avoid the consequences. But I had bank records showing my regular quarterly HOA payments. I had my file of all correspondence from the HOA, and I had my testimony about my signature being forged. The evidence was on my side. Then Patricia took the stand, and I watched her carefully. She was confident, almost cocky. She testified that the HOA had followed all proper procedures for the special assessment and foreclosure. She claimed the assessment had been properly voted on and that notices had been sent to all homeowners. Thomas began his cross-examination. Mrs. Hendricks, you are the managing member of Desert Winds Development, LLC, correct? Yes. And Desert Winds Development purchased Mr. Yates' land at the foreclosure auction, correct? Yes. Did you disclose this conflict of interest to the HOA board or the homeowners? Patricia hesitated. I did not believe there was a conflict. The auction was public and legally conducted. But you were both the seller, as HOA president authorizing the foreclosure, and the buyer, as owner of the LLC. How is that not a conflict? I was not the seller. The HOA was the seller. But you control the HOA as its president. I am elected by the homeowners to serve their interests. Thomas held up the meeting minutes for the special assessment vote. According to these minutes, only 15 homeowners attended the meeting where the special assessment was supposedly approved. The HOA has 63 properties. The bylaws require 60% approval for assessments over $10,000 per property. 15 is not 60% of 63. How was this assessment valid? Patricia's face flushed. The vote was properly conducted. Those who attended voted in favor. But the bylaws require 60% of all homeowners, not just those present at the meeting. You needed at least 38 votes. You had 15. The assessment was invalid. I disagree with your interpretation of the bylaws. Let me read you the exact language. Thomas picked up a copy of the bylaws. Section 7.3 states, any special assessment exceeding $10,000 per property must be approved by an affirmative vote of at least 60% of all homeowners. Not 60% of those present, 60% of all homeowners. 15 out of 63 is 24%. You did not have the votes. Patricia looked at her attorney, who whispered something to her. She turned back to Thomas. The board interpreted the bylaws to mean 60% of those present at a properly noticed meeting. Even though that is not what the bylaws say, it was the board's interpretation. And then you personally profited from this invalid assessment by purchasing Mr. Yates's foreclosed land through your own company? I paid fair market value at a public auction. You paid $75,000 for land worth at least $200,000, and you were the only bidder at an auction that was advertised in a small newspaper on a single day. That does not sound like a competitive public sale to me. Patricia's attorney objected, and Judge Morrison sustained it. But the point had been made. The courtroom was silent, and I could see Patricia's confidence cracking. Thomas pulled out another document. Mrs. Hendricks, I am showing you what has been marked as Exhibit 14. This is a certified mail receipt for a notice allegedly sent to Mr. Yates. Do you recognize the signature on this receipt? Patricia looked at the document. It appears to be Gabriel Yates' signature. Have you ever seen Mr. Yates sign his name in person? I do not recall. Mr. Yates has testified and Dr. Chen has confirmed that this is not his signature. It is a forgery. Did you forge this signature? Absolutely not. That is outrageous. Did anyone on the HOA staff forge this signature? Not to my knowledge. Then how did a forged signature end up on a certified mail receipt for a notice from your HOA? I have no idea. Perhaps the Postal Service made an error. The Postal Service does not forge signatures. Mrs. Hendricks, someone intentionally signed Mr. Yates's name on this receipt to make it appear he received notice when he did not. That is mail fraud, which is a federal crime. Patricia's face went pale. Her attorney objected again, calling the question argumentative. Judge Morrison sustained it, but told Thomas to continue. Mrs. Hendricks, I am going to ask you to provide a handwriting sample to the court right now. Would you please write your full name and address on this paper? The judge instructed Patricia to comply. She took the pen with a shaking hand and wrote her information. Thomas handed the paper to Dr. Chen, who examined it briefly and then nodded to him. Mrs. Hendricks, when did you form Desert Winds Development LLC? About 4 months ago. And what was the purpose of forming this company? Investment opportunities in the area. Had you purchased any other properties through this company before buying Mr. Yates's land? No. So you formed a company, and the first and only property you purchased was land that you foreclosed on through your HOA. Does that seem coincidental to you? I saw an investment opportunity. An investment opportunity that you yourself created by pushing through an invalid assessment and foreclosing on land owned by someone who never received proper notice? That is your interpretation. Judge Morrison had heard enough. She called for closing arguments. Patricia's attorney argued that the HOA had followed proper procedures and that any issues with the bylaws were internal HOA matters that did not invalidate the foreclosure. He claimed that the signature on the certified mail receipt was presumed valid based on Postal Service delivery. Thomas's closing was devastating. He methodically walked through each piece of evidence: the invalid vote on the assessment, the forged signature, the conflict of interest, the sham auction, the suspicious timing of the LLC formation. He argued that Patricia had orchestrated a fraud to steal my property, and that the court should void the sale and restore the property to me. Judge Morrison took a 15-minute recess to review the evidence. When she returned, her expression was stern. I have reviewed all the evidence and testimony presented today. I find the following. First, the special assessment was not properly approved according to the HOA bylaws. The requirement of 60% of all homeowners was not met. Second, the signature on the certified mail receipt is, more likely than not, a forgery based on the credible expert testimony of Dr. Chen. Third, Mrs. Hendricks had a significant conflict of interest in foreclosing on the property and then purchasing it through her own company without disclosure. Fourth, the auction process was inadequate to ensure a fair market sale. Based on these findings, I am granting the plaintiff's motion. The foreclosure sale is void. The property is to be immediately returned to Mr. Gabriel Yates with clear title. Desert Winds Development LLC is ordered to execute a quitclaim deed transferring the property back to Mr. Yates within 7 days. Mrs. Hendricks, I am also ordering you to pay Mr. Yates's attorney fees and costs, which I am setting at $25,000. Furthermore, I am referring this matter to the Yavapai County Attorney's Office for investigation of possible criminal fraud and forgery. Court is adjourned. The gavel came down. I felt like I could breathe for the first time in weeks. Thomas shook my hand, grinning. Patricia stood frozen at the defense table, her face white with shock. Her attorney was already packing his briefcase, clearly eager to distance himself from the case. As we walked out of the courtroom, I saw 2 men in suits waiting in the hallway. They approached Patricia as she exited. One of them held up a badge. Mrs. Hendricks, I am Detective James Carter with the Yavapai County Sheriff's Office. We need to ask you some questions about the foreclosure case we just heard about in there. You have the right to remain silent. Anything you say can and will be used against you in a court of law. Patricia's attorney tried to step in, but the detectives were insistent. They needed to interview her about the forgery and fraud allegations. Patricia looked like she might faint. Her perfect hair suddenly looked less perfect, and her makeup could not hide the panic in her eyes. Over the following weeks, the criminal investigation unfolded rapidly. The detectives interviewed Brenda, the HOA office manager, who admitted under pressure that Patricia had given her the certified mail receipt already filled out and told her to file it. Brenda claimed she had not known it was forged and had simply followed her boss's instructions. She agreed to testify against Patricia in exchange for immunity. Mark Sullivan, the HOA treasurer, who was also Patricia's business partner in the LLC, turned state's evidence as well. He testified that Patricia had planned the entire scheme 6 months before implementing it. She had identified my vacant land as valuable and had devised the plan to assess me with an inflated special assessment, ensure I did not receive notice, foreclose quickly, and purchase the property through the LLC at a low price. The plan was to hold the land for a few years and then sell it for a significant profit. Richard Hendricks, Patricia's husband, claimed ignorance of the forgery, but admitted he had been a willing participant in the LLC and the property purchase. The prosecutors did not believe his ignorance claim, and he was charged as an accessory. 2 months after the court hearing, Patricia Hendricks was arrested and charged with multiple felonies: fraud, forgery, mail fraud, theft by extortion, and abuse of fiduciary duty. The Attorney General's office also filed civil charges seeking to dissolve the HOA board and place the association under state supervision. The case made local news, with headlines about an HOA president stealing land from homeowners. I got my land back with clear title within a week of the judge's order, just as she had mandated. Patricia had no choice but to sign the quitclaim deed. I also received the $25,000 in attorney fees, though Thomas had done far more than that amount of work. He told me the victory and the precedent were worth more than money, and that he was considering writing about the case for a legal journal. The other homeowners in Desert Winds began asking questions about the special assessment they had paid. Thomas helped me draft a letter to all residents explaining that the assessment had been invalid and that they were entitled to refunds. Several homeowners filed small claims actions against the HOA to recover their payments. The HOA's insurance company eventually settled those claims to avoid further litigation. Patricia's trial was scheduled for 6 months later, but she accepted a plea deal before it went to trial. She pleaded guilty to 3 felony counts: fraud, forgery, and theft. She was sentenced to 4 years in prison with the possibility of release after 2 years for good behavior. She was also ordered to pay restitution of over $300,000 to me and other affected homeowners. Her attorney's license was suspended, as she'd been a licensed real estate attorney before becoming HOA president full-time, which added another layer of professional consequences to her crimes. Richard Hendricks received probation and community service for his role as an accessory. Mark Sullivan received a suspended sentence in exchange for his cooperation. The HOA board was reconstituted with new members who were elected in a special meeting. I attended that meeting and spoke about the importance of transparency, following bylaws and ethical leadership. The new board voted unanimously to abolish all special assessments that had been imposed under Patricia's leadership and to implement new safeguards to prevent future abuses. I also discovered that I was not Patricia's only target. During the investigation, it came to light that she had attempted similar schemes with 2 other properties in the neighborhood. Those foreclosures had not yet been completed, and the affected homeowners were able to stop them once the fraud was exposed. One of those homeowners, a retired teacher named Helen Crowley, thanked me personally for fighting back and exposing Patricia's crimes. The whole experience taught me several important lessons about HOA governance and the importance of vigilance. I learned that HOAs can wield enormous power over homeowners, including the ability to place liens and foreclose on property. I learned that this power can be abused by unethical people who see opportunities for personal profit. And I learned that most homeowners never read their HOA bylaws or attend meetings, which creates an environment where fraud can flourish. After everything settled down, I finally started building the workshop I had always planned for that land. It is a beautiful structure with large windows facing the red rocks, built from reclaimed wood and designed to blend with the natural landscape. I installed solar panels on the roof and a rainwater collection system. The workshop became my sanctuary, a place where I could work on personal projects away from the chaos of consulting work. I also became more involved in the HOA, attending every board meeting and encouraging other homeowners to do the same. Transparency became our watchword. Every assessment, every expenditure, every decision was documented and communicated to all residents. We implemented online voting for major decisions so that homeowners who could not attend meetings in person could still participate. Thomas Rodriguez and I became friends beyond our attorney-client relationship. He invited me to speak at a continuing education seminar for lawyers about HOA fraud and foreclosure defense. I shared my story with a room full of attorneys, emphasizing the importance of handwriting analysis and document authentication in fraud cases. Several attorneys approached me afterward with similar stories from their own clients, confirming that HOA fraud was more common than most people realized. Dr. Chen also became a valuable contact. She explained to me that forensic document examination was an underutilized tool in civil litigation, and that many cases involving questioned signatures were resolved without proper expert analysis. She encouraged me to spread the word that handwriting experts were available and could provide definitive answers in signature disputes. The local media coverage of Patricia's case had an unexpected benefit. It alerted other homeowners in different HOAs to the possibility of fraud in their own associations. I received emails from people all over Arizona asking for advice on reviewing their HOA's finances and challenging questionable assessments. I was not a lawyer, so I could not give legal advice, but I could share the lessons I had learned and encourage people to be vigilant. One email stood out. It was from a woman named Jennifer in Tucson who suspected her HOA president was embezzling funds through fake vendor contracts. She had reviewed the HOA's financial records and noticed thousands of dollars being paid to a landscaping company that never seemed to actually do any work. I connected her with Thomas, who took her case. It turned out her instincts were correct and that HOA president was also eventually prosecuted for fraud. The experience changed my perspective on property ownership and community governance. I had always thought of my home as a private sanctuary where I could live peacefully without interference. But living in an HOA meant accepting a layer of governance that could be either beneficial or oppressive, depending on who was in charge. The key was engagement. Homeowners who paid attention, asked questions, and held their boards accountable could prevent abuses. Homeowners who ignored their HOAs and assumed everything was fine were vulnerable to schemes like Patricia's. I also developed a deeper appreciation for the legal system. When I first found that foreclosure notice on my door, I felt helpless and angry. The system seemed rigged against me, with the HOA having all the power and me having none. But the courts proved to be an effective check on that power. Judge Morrison had listened to the evidence, applied the law fairly, and delivered justice. The criminal justice system had held Patricia accountable for her crimes. The system worked, but only because I had been willing to fight and had found good people like Thomas and Dr. Chen to help me. About a year after the trial, I received a letter from Patricia. It was postmarked from the state prison in Perryville where she was serving her sentence. I almost threw it away without reading it, but curiosity got the better of me. The letter was handwritten on lined prison stationery in that same blocky handwriting I had seen on the forged certified mail receipt. It was not quite as crude as the forgery, but the similarities were unmistakable. She had definitely been the one who forged my signature. The letter was not an apology. Instead, it was a rambling justification of her actions, claiming that she had been trying to improve the community and that I had been an obstacle to progress. She claimed the special assessment was necessary for important improvements, even though the money had actually gone into her own pocket. She blamed me for her imprisonment, saying that if I had just accepted the foreclosure, none of this would have happened. The letter was delusional and self-serving, confirming that Patricia still did not understand or accept responsibility for what she had done. I showed the letter to Thomas, who advised me not to respond. He said Patricia was probably hoping for some reaction that she could use in an appeal or clemency application. I took his advice and filed the letter away. It served as a reminder that some people never admit fault, even when caught red-handed. The workshop on my reclaimed land became the site of many gatherings over the following years. I hosted HOA board meetings there, community barbecues, and informal get-togethers where neighbors could discuss issues in a relaxed setting. The The building that Patricia had tried to steal became a symbol of community resilience and justice. I also started a blog documenting my experience and providing resources for other homeowners dealing with HOA disputes. The blog covered topics like reading and understanding HOA bylaws, requesting financial records, identifying red flags of fraud, and finding good attorneys. The blog attracted thousands of readers, and I received countless messages from people who had used my advice to challenge improper HOA actions in their own communities. One particularly rewarding message came from a man in Florida who had been facing foreclosure over bogus fines levied by his HOA. He used the information from my blog to hire a handwriting expert who proved that signatures on violation notices had been forged. His case was dismissed, and the HOA manager who had forged the signatures was fired and prosecuted. He credited my story with giving him the idea to challenge the signatures, which had saved his home. 5 years after the original incident, Desert Winds had become one of the most well-governed HOAs in the Sedona area. We had transparent finances, active homeowner participation, and a reputation for fairness. Property values in the community had increased significantly, and the community was thriving. The scandal with Patricia had been painful, but it had ultimately made us stronger and more united. I sometimes drove past Patricia's old house, which had been sold after her conviction to pay restitution. A young family lived there now, and they had painted it a cheerful yellow and installed a playground in the backyard. The house looked happy, which felt like poetic justice. Patricia had tried to build a real estate empire through fraud, and instead, she had lost everything. My vacant land, the parcel that Patricia had coveted and tried to steal, became more valuable than I had imagined. A developer approached me with an offer to purchase it for $500,000 to build luxury condominiums. I turned down the offer. The land was not for sale at any price. It represented something more important than money. It represented the principle that property rights matter, that fraud cannot be tolerated, and that ordinary people can fight back against corruption when they have the courage and resources to do so. The workshop I built on that land became my favorite place on earth. I spent hours there working on woodworking projects, reading, and simply enjoying the silence and beauty of the desert. The red rocks glowed in the setting sun, painting the landscape in shades of orange and crimson. The air smelled of juniper and sage. It was peaceful and perfect. I thought about that Tuesday morning when I had found the foreclosure notice on my door and how my world had turned upside down in an instant. I thought about the panic and anger I had felt, the uncertainty of whether I could win against an opponent who seemed to hold all the cards. I thought about the moment Dr. Chen had confirmed the signature was forged, giving me the evidence I needed to fight back. I thought about Judge Morrison's gavel coming down and her words declaring the foreclosure void. I thought about Patricia being led away by detectives, her carefully constructed scheme crumbling around her. Most of all, I thought about how close I had come to losing everything because one greedy person had decided my property would be better off in her hands. If I had not kept meticulous records, if I had not been willing to hire an attorney, if I had not insisted on getting a handwriting expert, Patricia would have gotten away with it. My land would be gone, probably developed and sold for a profit, and I would have been left with nothing but anger and regret. The experience made me an advocate for homeowner rights and HOA reform. I testified before the Arizona legislature in support of a bill that would require HOAs to use certified forensic document examiners when foreclosing on properties based on disputed notices. The bill passed and became law, partly due to the publicity surrounding my case. Other states began considering similar legislation. I also worked with consumer protection groups to develop educational materials about HOA governance and homeowner rights. These materials were distributed to new homebuyers at closing, ensuring that people understood what they were agreeing to when they purchased property in an HOA community. Knowledge was power, and educated homeowners were less vulnerable to abuses. The financial recovery from the case was significant. Beyond getting my land back, I received the court-ordered attorney fees and a portion of the restitution that Patricia was required to pay. The total came to about $40,000, which more than covered my legal expenses and compensated me for the stress and time involved in fighting the case. More importantly, The victory established legal precedent that helped other homeowners in similar situations. Thomas Rodriguez built a successful practice partly on the reputation he gained from my case. He became known as the attorney who would take on corrupt HOAs and win. He represented dozens of other clients in HOA disputes over the following years, and he frequently cited my case in his arguments. We remained close friends, meeting monthly for lunch to discuss legal developments and share stories. Dr. Chen's expertise became more widely known after her testimony in my case. She received referrals from attorneys all over the Southwest who needed handwriting analysis in civil and criminal cases. She told me that my case had been one of her most straightforward forgery determinations, but also one of her most important because of the precedent it set. She continued to testify in courts for another decade before retiring, and she always listed my case as one of her career highlights. The Desert Winds community continued to thrive under new leadership. The HOA board implemented policies that prevented conflicts of interest, required independent audits of finances, and mandated transparency in all dealings. The community became a model for how HOAs should operate, and board members from other associations would visit to learn about our practices. I eventually expanded my workshop to include a small guest house, which I rented out on a short-term basis to artists and writers who wanted to experience the beauty and tranquility of Sedona. The income from the rental helped cover property taxes and maintenance, making the land financially productive without developing it commercially. Guests loved the space and often left glowing reviews about the peaceful environment and stunning views. One guest, a novelist from Boston, wrote a book loosely based on my story. She changed the names and details, but captured the essence of what had happened: an ordinary person fighting against institutional corruption and winning through persistence and evidence. The book became a minor bestseller in the legal thriller genre, and she sent me a signed copy with an inscription thanking me for the inspiration. I read it in one sitting, marveling at how my real-life experience had been transformed into compelling fiction. The years passed, and the memory of the foreclosure crisis faded, but never disappeared entirely. It had been a defining moment in my life, a test of my character and resolve. I had faced an opponent who seemed more powerful, better connected, and willing to break the law to get what she wanted, but I had refused to back down. I had gathered evidence, hired experts, and used the legal system to achieve justice. The experience taught me that corruption thrives when good people do nothing. Patricia had counted on my ignorance and passivity. She had assumed I would accept the foreclosure without questioning it, or that I would give up when faced with the complexity of challenging it. She had been wrong. My willingness to fight, combined with Thomas's legal skill and Dr. Chen's expertise, had defeated her scheme and exposed her crimes. I often wondered what would have happened if I had not noticed that the signature on the certified mail receipt was forged, if I had not kept my old driver's license and credit cards showing my real signature for comparison, if I had not insisted on seeing the original documents. The forgery was the key piece of evidence that unraveled everything else. Without it, Patricia might have argued that I had received notice and simply ignored it. The forged signature proved deliberate fraud, which opened the door to challenging everything else about the foreclosure. The lesson was clear. Details matter. Documentation matters. Expertise matters. Fighting back matters. As I sat in my workshop on a warm evening, watching the sunset paint the red rocks in brilliant colors, I felt a deep sense of contentment. My land was mine, secured not just by a deed, but by a court judgment that could never be challenged. Patricia was in prison, paying for her crimes. The Desert Winds community was healthy and well-governed, and I had helped create changes in the law that would protect future homeowners from similar frauds. The workshop walls were decorated with photographs documenting the case: the forged signature, Dr. Chen's comparison charts, news clippings about Patricia's arrest, the court judgment. They served as reminders of what I had overcome and what I had learned. Visitors often asked about the photos, and I would tell them the story, emphasizing the importance of vigilance and the power of standing up for your rights. Gabriel Yates, software consultant turned HOA reformer and homeowner advocate. It was not a role I had ever expected to play, but it was one I embraced fully. The foreclosure battle had taken months of my life and thousands of dollars, but it had also given me a purpose beyond my day job. I had become someone who fought for justice and helped others do the same. The vacant land that Patricia had coveted remained undeveloped except for my workshop and guest house. It was my statement that some things were more valuable than money. The land represented freedom, justice, and the rule of law. It represented the principle that you could not simply take what belonged to someone else, even if you held a position of power and thought you could get away with it. Every time I walked onto that land, I remembered the battle I had fought and won. I remembered Patricia's shocked face when Judge Morrison voided the sale. I remembered the detectives approaching her in the courthouse hallway. I remembered receiving the quitclaim deed that returned the property to me. Those memories were sweeter than any financial profit I could have gained from selling the land. The story of HOA, President Patricia Hendricks, who tried to steal my land by forging my signature, became a cautionary tale in legal circles and homeowner communities throughout Arizona and beyond. It demonstrated that HOA fraud was real and prosecutable. It showed that homeowners could successfully fight back with proper evidence and legal representation, and it proved that handwriting experts could provide the definitive evidence needed to expose forgeries and win cases. Years later, I would receive occasional emails from attorneys or homeowners who had discovered my case through legal research or internet searches. They would ask for advice or simply thank me for fighting and winning, saying that my case had helped them in their own battles. Each message reminded me that the impact of standing up for your rights extends far beyond your own situation. The workshop became a gathering place not just for community events, but for strategy sessions with other homeowners facing HOA problems. I became an informal consultant, helping people understand their rights and connecting them with attorneys and experts who could help. It was volunteer work that took time away from my paying job, but it felt important and meaningful in ways that software consulting never had. Patricia was eventually released from prison after serving 2.5 years. I heard through the community grapevine that she had moved to Nevada and was working in retail, far from the real estate and HOA world where she had once wielded power. Her attorney's license was permanently revoked, and she faced years of financial hardship, paying off the restitution she owed. Her marriage to Richard had ended in divorce during her incarceration. Her fall from HOA president to convicted felon had been complete and irreversible. I felt no sympathy for her. She had tried to steal my property through fraud and forgery. She had abused her position of trust. She had hurt multiple homeowners in pursuit of personal profit. She deserved every consequence that came her way. Justice had been served, both civil and criminal, and the community was better off without her. The Desert Winds Homeowners Association became my home in a way I had not anticipated when I first moved to Sedona. I had wanted isolation and privacy, but the battle against Patricia had connected me to my neighbors in profound ways. We had been through a crisis together, and we had emerged stronger and more united. The community was no longer just a collection of individual properties governed by an association. It was a real neighborhood where people knew each other, looked out for each other, and worked together for the common good. My life in Sedona settled into a comfortable rhythm. Software consulting paid the bills, the workshop provided creative fulfillment, the guest house generated supplemental income, and the homeowner advocacy work gave me purpose. The red rocks that had first attracted me to this area became even more beautiful as years passed, and I made the land truly my own. This was home, secured through struggle and vindicated through justice. This was where I belonged, on land that no one could ever take from me again.